Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Mrs. Williamson. Good afternoon. We're here today to take up our next case for consideration and submission, cause number 1120-101CV, Clayton Mountain Development versus Suzanne Ruff. Mr. Jackson, are you ready to proceed?
I am, Justice Bailey.
You may.
May it please the court. As the court can see from Appellee's brief, the theme of their case is effectively that this appeal has been brought simply to delay. And that's been a repeated accusation throughout this case. And this court may have more experience with this case in general than I do. But ironically, the delays that have been occurring seem to stem from the result of Appellee's attempts to take shortcuts in this case. We're here today because of the severance of what was previously an interlocutory judgment. And this motion to sever that's brought us here was filed expressly for the intent to wrap up my client CMD's, that there could be an appeal immediately.
Is it your position there was never a final judgment entered?
That is one of our positions, Justice. And once the severance was granted, our position, even when we filed our notice of appeal, was that the judgment wasn't final, but we filed our notice of appeal out of an abundance of caution because the title on the judgment was final appeal. So, but in the motion to sever itself, the only grounds for their motion to sever that they alleged was so that Mike will appeal. He can appeal. He always appeals. And so let's make this a final judgment expressly for the purpose so he can get this appeal started. After that severance, as I said a minute ago, we were concerned that that judgment still was interlocutory, even though it had final judgment in the title. And then, as this court noted on, I think on April 30th, it abated this appeal and basically looked at the order and said it looks interlocutory to us as well. And even though severances are typically intended to maybe make things clearer or simpler or more convenient, this particular severance may have muddied the waters even more. And that's absolutely what this has done, because and then the court in its April 30th order instructed Judge Brotherton to clarify his order to determine whether it really intended to dispose of all issues as to all parties, which kind of brings me to the first maybe linchpin issue in this case. Judge Brotherton did on May 11th end up signing an amended order that is effectively the exact same order as the original interlocutory order, except it now has a Mother Hubbard clause. And I would submit to this court that there's two problems with that. The Mother Hubbard clause doesn't cure the fact that it's an interlocutory order. But more importantly, Judge Brotherton did not have authority at that time that he signed the amended order to sign that amended order, because the original assignment of Judge Brotherton to this case was expressly to case C-46164. When Judge Brotherton severed the case, he expressly stated that this shall be severed, and it was assigned a new cause number, C-46164-2.
Okay, counsel, we've read your brief on that issue. That's really more of a pure issue of law that we can decide. There's so much to go over. I'd like for you to not skip over. I don't want to interfere with your argument, but that's not what I don't think that we're primarily focused upon in your oral argument. We're more interested in, you've talked about the severance and that it's not proper. Tell us why it's not proper and why this is not a final judgment. Just kind of list for us why.
Absolutely. First, as far as the severance not being proper, severance is for the court to grant a severance. The issue that's being, or the claim that's being severed, Supreme Court has said that it should not be interwoven with the same facts of the underlying case. And in this case, the actual severance order provides that Suzanne's claims versus CMD, and I'm saying CMD is Clayton Mountain Development.
Sure.
Her claims against CMD are severed. However, in that order itself, it further goes and it voids 3 transactions. It voids a special warranty deed from CMD to Mar Living Trust. It voids a special warranty deed from Mar Living Trust to Clayton Mountain Partners, which is not a party to the suit at all. It also voids an assignment of developers' rights from Mar Living Trust to Clayton Mountain Partners. So what we have in this order are these transactions that are voided, to which CMD was a party, to which Mar Living Trust was a party, and Mar Living Trust remains a party in the underlying original cause of action. So there is still an ongoing lawsuit regarding Mar Living Trust's involvement in what Suzanne has claimed is an ongoing breach of fiduciary duties, among other things. So
Okay, so you're saying that the court should not have avoided those 3 instruments because it affects Mar's interest in those, and Mar didn't have an opportunity to litigate those matters?
Absolutely, and to the extent that those transactions are voided or even implicated in any way in this judgment, it's inescapable that those claims are interwoven with Mar Living Trust's continued participation in the underlying lawsuit. Same goes for, there's a Mar Living Trust, and that effectively Mar Living Trust has been
right. They then conveyed to Clayton Mountain Partners, right?
That's correct. And potentially Clayton Mountain Partners now has claims against Mar Living Trust for breaching the warranties that are in the deeds. And effectively what's happened with Mar Living Trust is they've effectively been on the receiving end of a summary judgment when there has been no motion for summary judgment. They've just been swept along with CMD in an order granting sanctions, and then subsequently what's styled a final judgment.
So you're saying, number one, the reason why the judgment can't be final is because he's voided those 3 instruments, correct?
Correct. Well, and that Mar Living Trust, it doesn't dispose of all issues as to all parties, because Mar Living Trust still has claims and defenses and is still a party.
Okay. And so that's your number one. What's your number 2 reason why you say this is not a final judgment and can't be a final judgment?
Well, it indicated that it was an improper severance because it was brought solely for the purpose of expediting the appeal. And that's just, it's a fundamental, it's axiomatic that severances are not intended to serve as just a springboard to an appeal to move a case along. I know that was what the plaintiff intended, and that's all that she intended, because that's expressly the sole thing that she stated in her motion for severance, was that Mike always appeals, and so let's get this show on the road. And that's not a proper grounds for severance. So with respect to the judgment.
Okay, what about the issue with regard to damages? Did the court take up damages? Was there a hearing on damages? Is that a problem?
That is a problem. The court did not take up any kind of hearing related to damages. There was a jury demand on file at the time that the court took this up, and with respect to the damages, any claim for unliquidated damages, they're not confessed just by virtue of the fact that a sanction's been handed down that struck the pleadings of CMD. And when I say struck the pleadings, specifically their answer in affirmative defenses. So with respect to the remaining issues, the relief that was granted to Suzanne in the judgment was a finding that she's the owner of CMD, so to speak, and that these 3 transactions we talked about are voided, and Suzanne's the sole owner of CMD assets. That type of relief should have been the subject of an evidentiary hearing. Now, the appellee claims that no, she had it in her petition, therefore it's been confessed and no hearing is necessary. But they're wrong. They cited a case, the Brantley case, which is, I believe, the only case that they relied upon as to this issue. And Brantley dealt with a default, effectively a default judgment after striking of pleadings when there was an earnest money contract that was the subject of the suit. In that case, you had a suit that was strictly on a written instrument. And when you have a suit on a written instrument, then yes, perhaps that can be confessed. But in this particular case, the relief that Suzanne sought was not relief that was in a written instrument. The court had to find that this property that Suzanne claims that she's the beneficiary of a constructive trust, the court would have had to have found that CMD was indeed one of those properties over which she was awarded this constructive trust. Before it could even before it could grant the relief that it granted. And the court, having no evidentiary hearing, it leaped from a very vague and nebulous original. I say original, I think at the time it was the 6th amended original petition, but that 6th amended original petition, it didn't make the claim that Suzanne was the beneficiary of a constructive trust as to CMD. It did not have any references or attachments to any contract or any other written instrument onto which she could rely to get the relief that was granted in the judgment. She made some factual allegations, and effectively all of the defendants have been sort of lumped together as one fungible entity without any real explanation as to what any specific defendant did, other than maybe Michael Ruff in his individual capacity. And
well,
so
there are some things that the court identified that CMD did or did not do, right? There was authorizations that were supposed to be executed. They were not executed. There were corporate documents of transfer that the court ordered to be produced. CMD represented to the court that all the documents had been produced. Then Suzanne Ruff comes up with a document that had been executed during the arbitration, 4 days before Michael withdraws from the arbitration. There's a transfer of property from CMD to MAR, right?
that's correct,
And
Justice.
that document was not produced. And that is exactly the type of document that Suzanne had said, this is what we're looking for, and this is what we're afraid of. We're afraid that there's a shell game going on and properties being transferred, and we want all these documents to ensure that that hasn't happened. And CMD did not produce that document, even though it existed as of 2017, but wasn't filed until May of 2019, right?
That's my understanding of the record, Justice.
Okay, all right.
Sure. But I don't think that addresses the issue as to whether CMD was entitled to its day in court on what is effectively unliquidated damages, or the portion of the case that didn't rely upon a written instrument. Even if the court, as a result of, let's just say, take it at face value that CMD did indeed fail to deliver what it was supposed to have delivered.
Yes.
when it came to granting relief to Suzanne, the law is clear that that there has to be evidence unless it's on a written instrument. And so with respect to what's been done here is she's been, again, the court found that she's the constructive trustee or the beneficiary of a constructive trustee over CMD. She's the owner of all its assets. And again, this stems back from the judgment that the Dallas Probate Court signed, which basically effectively said that any entities that were funded with Suzanne's money, she is a constructive trustee over. But CMD is not one of those. And there's and forgive me, there was a laundry list of entities. CMD was not among entities. And
right.
So whether she was entitled to the relief at some point after an evidentiary hearing is really not even the issue I'm raising. The issue I'm raising is that the fact that it was this relief was granted without any evidence whatsoever. There was no evidentiary hearing.
Okay, well, let's assume you're right on those 2 points. What we would have is an interlocutory judgment that takes care of liability, the liability issues, and what we would have left is the court would have to have a damages hearing, and the court would have to decide whether severance is proper under the circumstances, correct?
That's correct. Absolutely. I would agree with that.
Yeah.
And with respect to, again, I guess the linchpin issue, which is a pure question of law, is the effect of that assignment of Judge Brotherton. With respect to, and I guess to add to what you just said, an issue in addition to the severance and the propriety of that, and the necessity of an evidentiary hearing, there's still the issue of Mar Living Trust, who's effectively got a judgment against it without ever having a single day in court. Mar Living Trust was not a party to any of these disputes that led to the judgment that we're here about today.
And they were a party in interest, is what you're saying. As to these deeds, they're a party in interest.
That's correct.
They should have been involved in a hearing of some type.
I think before the court absolutely just voided out the transactions that they were the grantor as to, or even the grantee of. Again, there was 3. The first one being the conveyance to CMD, and then the conveyances from CMD. They were entitled to their day in court as to those transactions. Absolutely.
Right. Okay.
So, really, I kind of fast forwarded through everything I've got.
Yeah,
I don't want to waste the court's
that.
time. And no, it's. I think if I said anything more, I'd just be listening to myself talk, and whatever time I have left, I'd like to reserve for a rebuttal.
Okay. Right.
Thank you very much, Mr. Jackson. Mr. Donheiser, are you ready to go?
Yes, I am, Your Honor.
You may proceed.
Thank you.
I would like for you to address those issues that we've talked about. Let me hear the other side of that argument, would you?
And let's start with finality, because that was the first issue the court raised.
Yes, sir.
The severance was all claims against Clayton Mountain Development. The judgment disposes of all claims against Clayton Mountain Development. We need to step back a little bit here and look at what this case is about. This case is about the 7R Ranch, which was awarded to Suzanne Ruff in that judgment. Forget about the whether CMD is listed on Exhibit A. The 7R Ranch is. Mike Ruff took legal title to that ranch in order to develop it for Suzanne Ruff. He didn't. He stole it. That's judicially established. As to Clayton Mountain Development, we are interested in the portions of the ranch, because Mike divided it up among a whole bunch of different entities.
Right. So we're talking about 2,000 acres, right?
4,000 acres, Your Honor.
Right. It was 4,700 acres, but only 2,000 were transferred, right?
transferred to
To
Clayton Mountain
Clayton
Development.
Mountain Development, right.
Right. The other 2,000 have been transferred to other entities,
Yes, sir.
some of which are defendants, some of which are no longer defendants, having filed for bankruptcy.
Right.
So this shell game is very elaborate. It's not a 3 shell game. It's a 200 shell game, because you're only dealing with Palo Pinto. You're not dealing with Dallas and other shells.
Yeah, but we're aware of them, and we know the number of entities that have been listed, and there are more in addition to those. So we see the frustration. We do see it.
Yes, Your Honor. And so the property transferred to Clayton Mountain Development, that issue has been resolved by this judgment. That's all the claim against Clayton Mountain Development is. So the judgment is final. There are no other claims. Now let's get back to this.
Okay, let me ask you a question about that. After the judgment, you filed a 7th Amendment petition, and it included claims against Clayton Mountain Development.
Yes.
Are you saying that all those claims are resolved in this judgment?
Absolutely.
Okay.
Until there is a final judgment, even though we had the judgment against Clayton Mountain, we don't want to non-suit them by dropping them out of the suit before the judgment is final. You don't do that. You keep the claims against a party, even if those claims have been resolved, until there is a final judgment. It's basic procedure 101. So it's final. What Mike is complaining about is, well, what about the rights of these other parties? First, let's step back. In August of 2017, Suzanne Ruff filed a Liz Pendens.
What do you contend that the Liz Pendens, what's the effect of the Liz Pendens, other than it's giving notice to anybody who takes that property that there is a claim?
It gives notice that there is a claim, and it gives those parties an option. You can either do nothing, and the claim may be resolved against you and your title may not be good, or you can intervene and protect your title. Both of these parties that they're complaining about, Clayton Mountain Partners, which we all know is Mike Ruff, and the MAR Living Trust, which is Mike Ruff, chose to do nothing, neither intervened. But MAR was joined. MAR was a party during all of these proceedings. It was a party at the June 2018 sanctions hearing. It was a party at the time of this. It did nothing. It claims now that it had an interest in this property, and it also claims that it is the owner of Clayton Mountain Development. It is the sole member of Clayton Mountain Development. It was a party. It did nothing to protect its interests. It sat there. It let the entity of which it is the owner, the sole owner, violate 3 consecutive discovery orders without taking any action to protect it, to make sure it complied.
Is it your position that since they were a party to the lawsuit and they're involved, or at least given notice of all of these hearings, they have a duty as a party in interest to make their interests known and to make their arguments, put their arguments before the court?
Absolutely, Your Honor. And it's even worse than that. They're represented by the same lawyers. Mm-hmm. Mr. Jackson represents them both. Before him, Mr. Helber represented them all. These entities are alter egos of each other, basically. And furthermore, Mike Ruff is the trustee of the MAR Trust. Mike Ruff has been a party since January of 2018. There's no due process problem of them not getting notice and an opportunity to be heard. They were heard. The MAR Trust appeared at that sanction hearing.
So your argument is that whatever Mike Ruff knows, he has on all hats at the time, not just his individual hat, he has on all hats.
Yes, the knowledge that he has is imputed to each of these entities.
Okay.
Have you alleged any alter ego theory?
Absolutely, Your Honor. Our petition, and it's before you in many other cases, has been criticized for its length. But certainly in, I think it's paragraphs 54 through 65, we allege alter ego.
Okay, Michael resigned as the manager from CMD in 2018, correct? January of 2018.
That is what Mr. Wyde said. Mr. Wyde was a prior attorney. There's a laundry list of attorneys who've appeared in this case on the defense side. He said, but any resignation of Michael Ruff and any appointment of a new manager were also required to be produced by 3 consecutive orders of the trial court and never were. So we don't know. All we have is Mr. Wyde's word, and I shouldn't say that because I think there's deposition testimony from Mike Ruff where he says he has resigned but doesn't know who has been appointed yet.
Right.
The theory is that it's borderline management, a new entity.
Right.
I've heard one appeal already from borderline. So the argument that they didn't have knowledge is defeated by the Liz pendants. If there is a Liz pendant and you buy a piece of property, you run the risk that it's going to be taken away from your grantor. And that's what Liz pendants is for. And that's why they were so eager to get it lifted. You have the transcript from that hearing, I think, but you certainly have the motion to lift the Liz pendants and Judge Moore's order denying it. As to the severance, there are similarities between the claims against Clayton Mountain and the other defendants, no doubt about it. But they're not intertwined because they deal with different property. But more importantly,
Okay, would the evidence be different? Yeah, I mean,
some would.
isn't the issue on severance is how does it work out in court? If I can try it in several cases and not interfere with the defenses or the lawsuit again of other people, then I can sever it. If they're just intertwined so much that I can't do that, then I can't sever it. Isn't how it works out in court the issue that we're dealing with on whether the severance is proper or not?
And that's why exactly what you're talking about is what makes Clayton Mountain Development different from the others. The other defendants don't have a judgment against them. There is no fact issue left as to Clayton Mountain Development. It has defaulted. And the courts see this all the time. Where
is a fact issue that's left is unliquidated damages. Is that a fact issue that's left?
Absolutely not, Your Honor.
Why?
There are no unliquidated damages. If you look at the judgment, there is no money awarded. That is unliquidated damages. Here, when you default, and CMD defaulted, you admit the allegations, the factual allegations of the plaintiff's petition. All 17 pages of them, or however long it is, 68 paragraphs or more.
Yeah, this wasn't a default, it was a sanction, and so the court can assume that the defenses have no merit, right?
That was the first sanction,
Right.
the obstructive affirmative defenses. The second sanction, that was to get them to comply. We'll strike your affirmative defenses, so comply. When they didn't comply with that sanction order, the answer was stricken. So it is a default. And so they have admitted the factual allegations, which includes that Clayton Mountain Development was created and funded with monies misappropriated from Susanna Ruff per the judgment. And the judgment is not limited to Exhibit A, the laundry list. It is any entity. Because, of course, also in the AAA, Mike didn't answer discovery, so we didn't know the names of all of the entities. He wouldn't tell us. He didn't mention Clayton Mountain Development. So the fact that Clayton Mountain Development was established and funded with monies taken from Suzanne Ruff is admitted by the default. Once that is admitted, there's nothing left. We didn't ask for money damages. If we'd asked for money damages, he'd be absolutely correct. But he didn't.
Yeah, you were saying you didn't know the name of CMD at the time of the arbitration, right?
Right.
But was this case going on at the time of the arbitration, or?
Yes, Your Honor, this case was filed, the arbitration was ordered back in 2013. This case was filed in 2014.
Okay.
Immediately
So
stayed.
CMD was part of the lawsuit before the arbitration concluded? No. It was not?
No, it was added later. The original 5 defendants who were sued in 2014 did not include CMD.
Okay.
They included the 5 entities which we knew had property.
Mm-hmm.
The case was stayed.
Right.
Pending the arbitration.
Right.
On those 5 defendants' representation to Judge Moore. This was their affirmative representation that the arbitration would solve all issues in this case.
Uh-huh.
Yeah, well, we can all laugh at that because it didn't. They misrepresented it. What they meant was, if we win, it will resolve all cases, but we'll continue to fight otherwise. Now, those original 5 defendants were gone. They're in bankruptcy.
CMD is left.
Well, there have been additions since then. That's why we're up to the 8th amended petition, as to find out not only older entities, but during the pendency of this case, after the arbitration award, Mike Ruff continues to create new entities and shuffle it around. It's not part of this case, but as the court knows, you have several other cases involving the Ruff family litigation. I think one of which is being submitted without argument today, involving new entities that he uses to shuffle around the property. It's still being.
Was there ever an order that he could not create new entities?
No.
Okay.
I'll apologize to the court. It never occurred to us that he would do that. We knew he would move property, and so we have orders which he's violated from both Judge Moore and from probate court here in Dallas, prohibiting him moving it, but he's continued to do it. He's moving property as we speak, probably.
Okay, so what's your answer to MAR, M-A-R, that says, gee, you've taken our property without us having a hearing on that?
They did have a hearing. They were present at the first hearing where the affirmative defenses of CMD were struck. They were there. They chose not to come to the second, even though their lawyer was there. He only announced for CMD. He didn't announce for MAR.
But they have notice of it because their attorney is there.
And they're party. They got
Mhm.
the notice of hearing and the motion for judgment, and I think it was amended motion for judgment that was being heard at that point, were filed using the electronic system, and service was made on all of their lawyers.
Uh-huh. Well, you filed a motion for sanctions, and then you amended that motion for sanctions, and you attached the 3 documents that were then voided by the court. Did Mar have the opportunity to come in and argue, gee, you can't do that, this is our property and we have a right to have a hearing on it?
It was served on them. They absolutely had the right to be present. Their lawyer was present, announcing only for other parties.
Okay, did your sanction motion request that those deeds be voided?
Absolutely, Ron. The
Okay.
amended motion attaches them, specifically attaches them, and says these 3, 2 of them are deeds, one's an assignment of interest.
Yeah. One is a memo of an assignment. I didn't see the assignment. I saw a memo that there had been an assignment, but I don't see the assignment. Is there an assignment in the record?
Know of, because nobody answers discovery in this case. Nobody.
Okay. All right.
So no, I haven't seen that. And I haven't seen Mike's withdrawal as the manager of Clayton Mountain Development. I
Okay.
mean,
But you requested in your motion that Mar got that these instruments be voided. Is that right?
Absolutely.
Okay.
And of course, there's also the Liz pendants, which puts you on notice to check the court, see what's going on. The Liz pendants lists the court, lists the cause number.
Does it describe the property?
It includes, it attaches the property description, which
Okay, because we don't have a copy of the Liz pendants in the record.
I think you do, Your Honor.
I have not seen, if you can point me to where the Liz pendants is in the record, then I would like to see it.
You want to wait while I look?
Not right now. He'll have an opportunity to make his argument, and then you can, I'll wait, once he concludes, I'll wait for a minute, and then you can tell me if you've got it or not.
Thank you, Your Honor. And in that case, I'll turn it back over to Mr. Jackson.
Okay, thank you.
Thank you very much, Mr. Jackson. If you'll give us the time to reset.
Sure.
All right. Now you can go with rebuttal.
Very briefly, Mr. Donheiser made the statement that once you put something in a petition and there's a default, you admit all factual allegations in that petition. That's just not what the law is, Justices. If I'm rear-ended at a stoplight and have a little bit of whiplash and I file a lawsuit claiming personal injuries and the defendant defaults, the liability portion is confessed. And even if in that petition I say I have suffered $100 million in damages, that is not confessed. That is not a liquidated damage just because I've made mention of it in a petition.
In the default hearing, you have to put on evidence of those damages.
That's correct. And
Right.
and just like that situation here, there had to be evidence that CMD was an entity that was implicated by this establishment of constructive trust over these entities. They're just not in the pleadings, and the relief that was granted is not relief that stems from a written instrument. So my point is that statement that Mr. Donheiser set forth is absolutely incorrect.
Okay, he's saying, gee, we're not asking, we didn't get a judgment for money damages. We got a judgment that puts Suzanne in as the sole owner of CMD.
Well, that's true. I mean, damages don't come just in the form of money. injunctive relief has been deemed and called and referred to as a form of common law damages, even though it's not just money. Even the Marr case that we cited wasn't about money damages, but it was a divorce case. But there was a default that I think pleadings were actually stricken in that case. But relief other than money damages can constitute unliquidated damages for purposes of this concept. The unliquidated damages would really envelop any kind of relief that's not already dictated by a contract. Again, the case, the Brantley case that they referenced in their brief was some specific performance was ordered because the underlying contract called for the parties to, it was a real estate contract. The buyer was entitled to that relief underneath the contract. Here, there is no contract. The relief that the court granted could only have been granted by hearing evidence as to what entities Susie was the beneficiary of as far as these constructive trusts go. So,
Okay, could the arbitration judgment that was confirmed by the probate court, could that be the source of the damages that the court orders that she is the sole owner of CMD?
I would submit not, but I would submit particularly not now because CMD is not even listed in it. You can't look into the four corners of that arbitration award and go, Susie is the owner of CMD, because it's not there. So maybe if it were there, arguably the argument might hold some water, but here CMD is absolutely, it's not mentioned in that arbitration award or in the subsequent judgment that ratified the arbitration award. So to answer your question, I would submit that there's no way for that arbitration award to sort of serve as a written instrument that the court could base its judgment on, because that written instrument has no reference to CMD. And then with respect to the same lawyer representing the different entities, just because a lawyer shows up on a hearing for a motion to compel for one defendant doesn't mean that other defendants, if other defendants represented by the same lawyer were to have shown up and make their arguments, I think Judge Brotherton would rightfully look at those other defendants in that circumstance and go, what are you doing here? They were not parties to that particular issue, and they were rightfully not part of it.
Okay.
Thank you very much, Mr. Jackson. Mr. Donheiser?
I have it listed as Supplemental Clerk's Record, Volume 1 at page 31.
Okay, thank you very much.
You'll have to figure out what Supplemental Clerk's Record 1 means, but that's what I have in my brief.
That's a very common thing.
Is it safe to say that neither Mike nor Susie are on either's Christmas card list anymore?
I think that's safe to say.
Okay.
I think Susie's still on Mike's, Justice Trotter, but
Is she?
I think I can say that she's not getting them, at least.
Thank you very much for your argument today.
Thank you.
Ms. Williamson will come back on and she will adjourn us for the day.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.
Thank you.
Thank you, gentlemen.
may we be excused.